We then move on to this idea of access. And an effective legal system provides ways for all people in the community to resolve their disputes. This means there are different dispute settlement processes for different types of disputes. And the reality is, if you look at the photos here for legal aid, you'll see people who seem to be disadvantaged, maybe homeless, maybe they have a status as an Indigenous Australian, which typically might mean that they are subject to disadvantage. And it might mean that paying for a lawyer is not as simple as just paying for a lawyer. They might not be able to afford it. In that case, they don't really have access to justice. So legal aid, a government-funded legal service for people who cannot afford to pay for a lawyer. Civil actions in small cases between a consumer and a business can be heard by a tribunal like VCAT at a relatively low cost, so that people who can't normally access justice can find a way in a low-cost forum or place to have their case heard. And in criminal cases, for serious indictable offences, a committal hearing is used to determine whether there is sufficient evidence for a trial to proceed in the county or Supreme Court. Appeals also allow people to check that a case has been heard correctly. You can appeal to a higher court. And last of all, T, timely resolution. If disputes take too long to resolve, the community loses confidence in the legal system. This then takes away from social cohesion. Basically, I lose all trust that justice can be done. So in an effective legal system, disputes are resolved in a timely manner. Now remember, timely does not mean fast or quick. Rather, it means within a reasonable time, depending on the complexity of the case. So for example, you couldn't take a speeding fine case and then a mass murder case and expect that both cases can be dealt with by the courts in the same amount of time. It's not saying that at all. It's not saying it just has to be as fast as it possibly can be. It's saying given the complexity of the case, in this case, the murder is a lot more complex than the speeding fine case, depending on the case that you're looking at, is it being dealt with in a reasonable amount of time? Now, some processes and procedures also exist to minimise delays. Here are some examples. Tribunals like VCAT, which you're familiar with, allow for faster resolution of smaller claims. Why go to a court and deal with all of the costs and time involved in going to court when a tribunal like VCAT can in some cases resolve a dispute within a matter of hours? The Magistrates Court requires claims below $10,000 to go directly to arbitration. And don't confuse that with the $100,000 limit they have for civil claims. This is $10,000, so actually a very small amount to be suing for. And they're saying, don't waste your time in the Magistrates Court. Go straight to arbitration. And again, it may be the case that in a very short amount of time, a resolution to that dispute can be achieved. The County Court has reduced delays in regional Victoria by increasing the number of circuit sittings, on the number of times they visit the county courts in country Victoria. And because they're visiting more often, people aren't waiting for the judges from the county court to be visiting their area to have their case heard. And in that case, they have a more timely resolution of their dispute as well. There are also specialist areas. For example, in the county court, they have a specialist sexual offences defence unit. And in cases that involve sexual offences, it's often the case that the victim, who might need to give evidence, needs to be protected from having to relive the whole awful experience again in the courtroom. And there are certain procedures that are put in place to make sure that that is minimised. Having a specialist part of the county court to deal with that means that they're used to doing it and they can do it more quickly. They're not having to reinvent the wheel every time that type of case comes before the court. So there's a lot of information on this next slide here, but this is the guts of it. This is the skill that I need you to really get on top of, and we're going to be doing it again and again and again. We'll use this FAT table, and FAT refers to fair and unbiased hearing, access to dispute resolution, and timely resolution. And we can use this framework simply setting up a table, to have a look at particular case studies. We can use it to look at particular features of our legal system and break it up into smaller parts so that we can say, well, is this effective or not? Now, you'll see that I've left a link at the bottom here, and I want you to go and visit that link and read the article there. It looks like this. This is a real-life article, as you can see, from The Age newspaper. It's in Victoria. It's from a couple of years ago. And it's called Judge Delays Criminal Trial to Allow Legal Aid Funding. And you'll see here it's in relation to a decision that a Supreme Court judge has made to make sure that basically a fair trial occurs. Now, what you need to do is read carefully through this article and try and fill out the fact table. And you'll see I've added some questions in this fact table on your screen that might help you pick out the issues that I'm looking for. So for fair and unbiased hearing, have a think about what is unfair in the situation and what has the judge done to make sure there is fairness. When we talk about access, who cannot access the mechanisms of dispute resolution here? Who can't get in? And why not? And then in terms of timely resolution, what is the consequence of not having legal aid? Who is suffering from all of this? And think beyond just the person who is accused of the crime. Who else might suffer from this case being delayed? So I'll leave that to you to do, and we'll certainly discuss this in class.